Hello and welcome to our webinar on the Digital Personal Data Protection Act 2023. On behalf of Khaitan and Company, I would like to extend a warm welcome to each one of you. I am Supratim Chakraborty, partner in Khaitan and Company, specializing in data and technology related laws. I've been fortunate to have assisted the Government of India in overhauling some of the digital laws, but today I'm your moderator and co-speaker along with my fellow partners Anisha Chand, Walia, and Shobhit Chandra, whom I'll be introducing in detail very shortly. But before that, the webinar agenda and some housekeeping rules. We are all aware that the Digital Personal Data Protection Act is India's first comprehensive national legislation on data protection. This legislation is supposed to dramatically reshape how businesses handle personal data. The agenda of the webinar today will be to explore the key aspects of this particular new law, the challenges that it poses for businesses, and how businesses may go about with their compliances. This would be followed by question and answers. We have already received a number of questions from the audiences. If you have any questions, please do put your question in the portal that is been provided in this system. If we cannot cover your question within this session, we will be responding to you through email separately, be rest assured. And also, after this webinar, you will be receiving a copy of the presentation and a link to the recording of the webinar. With this, let me introduce my co-speakers and partners for today. Anisha Chand. Anisha is a partner in the Competition, Antitrust, and Data Privacy Practice Groups of Khaitan and Company. She is a certified CIPPE professional. She advises clients in digital tech interface on a variety of issues, such as, in both these aspects of competition and data. Anisha has been consistently recognized for her expertise in Chamber and Partners, Who's Who Legal 500, IBLJ, etc. The list is long. Next is Walia. Harsh is a partner in the TMT and Data Privacy Practice Groups of Khaitan and Company. Harsh advises on regulatory areas such as data protection, intermediary liability, OTT services, content regulation, etc. He has been representing clients before the Ministry of Electronics and Information Technology and also the Department of Telecommunication on matters and also in relation to policy advocacy. Harsh has been consistently ranked by for TMT and also data practice by Legal 500 Asia Pacific rankings. He has been awarded the Data Protection Lawyer of the Year in 2023 by Corporate INTL Global Awards. Also, recently, Harsh has featured in the ALB India's Top TMT Lawyers 2023. Next is Shobhit. Shobhit Chandra is a counsel in the TMT and Data Privacy Practice Group of Khaitan and Company. He works closely with several Indian and multinational clients on areas such as data protection, intermediary liability, encryption, decryption, cybersecurity, gaming, telecom licensing, etc. He has also been recognized as a recommended lawyer for TMT and data protection by Legal 500 in the 2022 Asia Pacific rankings. Enough, and I think now we should get started with the presentation. First, let's talk about the historical background of this particular law. Next slide, please. So let's see how things have progressed. Okay, it's been a topsy-turvy journey, I think, of about 6 years now, and somewhere it kind of became a joke that you guys have come up with another draft. But anyways, here is the quick snapshot of the entire journey. We are all aware on 24th of August, the Supreme Court of India gave in a landmark judgment, the KS Puttaswamy versus Union of India decision, established privacy as a fundamental right under the Constitution of India. Incidentally, on 31st of July 2017, Justice B.N. Sri Krishna Committee was formed to propose a data protection law for India. He traveled across the country and a number of consultation meets took place. It's worthwhile to note that our data privacy team members from Khaitan and Company attended every single consultation meet that took place at that time, and we gave very valuable inputs to the committee. Also, during the present version of the law, its consultation, etc., we have given a number of important inputs. Quite a number of them have been actually incorporated and imbibed into the law. But anyway, so the journey continued, and so Justice Sri Krishna then gave his report to the Ministry of Electronics and Information Technology on 27th of July 2018. Thereafter, the 2019 bill, the Personal Data Protection Bill 2019, was presented in Lok Sabha on 11th December 2019, and it was referred to the Joint Parliamentary Committee. You would remember, at that time COVID happened, etc. Anyway, so there was a long deliberation, extensive one, and in 2019, unfortunately, that bill was withdrawn because there were, a number of recommendations, etc., were provided. It was thought appropriate by the government to withdraw that particular bill, and they presented a new version, which is the Draft Digital Personal Data Protection Bill 2022 on 18th of November 2022. Fast forward to 5th July 2023, you know how quickly it happened. This particular bill, the Digital Personal Data Protection Bill 2023, was passed by the Lok Sabha, which is the lower house of the parliament, on 7th of August 2023, and by the upper house, which is Rajya Sabha, on 9th of August 23. Thereafter, it received presidential assent and was published in the official gazette on 11th of August 2023. And the enforcement related notifications are yet to come out, so let's wait for that. But I think it is about time now to stop talking about the history and start looking into the future. So for that, I would call upon my partner and co-speaker today, Anisha Chand, to take over. She's going to talk about some of the very critical pillars of this particular new law, and these are important definitions, the applicability provision, the grounds of processing personal data, privacy notice, and consent manager. Over to you, Anisha.
Thanks everyone for joining in once again, and thank you, Supratim, for condensing this 6-year-long journey into a single slide with key milestone. So we obviously have miles to go from here, but at least we've begun. I'm going to take this discussion forward now by explaining certain key definitions that are fundamental and pivotal. Next slide, please. To understanding this law and decoding this law better. So we'll talk about what personal data means. So the entire edifice of this law is designed to protect digital personal data. We really need to understand what it means. And the definition provided under the law is fairly simple. It says personal data means any data about any individual who's identifiable by or in relation to such data. So as you can see, there is no prescriptive definition, or there's no list of items that have been called out, which was sort of the case when you look at Section 43A of the Information Technology Act and the SPDI, or Sensitive Personal Data Protection Information Rules. So there is no prescriptive definition anymore. It is broad-based. It provides a lot of flexibility such that one or more items put together cumulatively will result in being qualified or being seen as personal data. So what we have now is a really flat, homogeneous structure. There is no distinction between personal data, sensitive or critical personal data, which were some expressions and some definitions that we had seen in the predecessor iterations of this law. This is also in contrast with what we see in GDPR, that recognizes certain special categories based on your racial or ethnic origin, your political views, biometric data. These are all special categories even under GDPR, but we don't have that anymore. Now, next is the three chief actors under the act, as I like to call it. One is the data fiduciary. This person in this entity is nothing but the data controller. Then we have the data principal, again popularly called the data subject internationally. And lastly, we have this entity called the data processor, which is essentially a universally accepted term anyway. So it's crucial for organizations to understand who they are based on these definitions and what they do. We'll take a quick look at what these definitions entail. So we have the data fiduciary. He's the person who's determining the purpose and means for processing. So you are the person, or the data fiduciary is the person who is masterminding the entire data collection process, potentially to use it in furtherance of a business. He is the one who's interfacing and determining how this data needs to be used. Then we have the data processor. He's the one who's simply acting and processing this personal data on behalf of the data fiduciary. So he is essentially an agent or a service provider. For instance, if you have a payroll processor, or if you're you're a cloud service provider, then potentially you are not determining the means for which the data will be used in your own independent manner. It's something that you're following in terms of instructions from the data fiduciary, right? And then we have data principle, which is essentially you and I, individuals to whom the personal data relates, and where such individual is a child or a person with disability, it includes parents or lawful guardians of that person. Data processing, again, a very important definition that cuts across the entire law. It includes, as you can see, it's a very exhaustive definition. It's a catch-all. It's very broad. It also includes storage. And this is sort of largely consistent with what we see under other laws also. Next slide, please. Right. The next important piece is to understand when and how this law is going to be applicable to you, to organizations. So it's important that we understand when does this law apply to you. So the Act, very simply, it applies to processing of digital personal data in India, where the personal data is either collected in digital form itself, or where it is collected in a non-digitized form but is subsequently digitized. So again, the classification of offline, online, that's disappeared, that's gone away. What we're worried about and what we're concerned about is whether the format is digital or not. So just to give you an example, when you walk into official premises, you have a visitor's registration book and you may be giving your details manually. If that is sort of transferred into or entered into a computer, then it becomes a digital record. Similarly, if you have a physical document which you then scan, then it sort of derives or transforms into a digital personal data character. Right. So now, consistent with the international practices, our law also has extraterritorial application. What do I mean by that? It means that simply because you're sitting outside of India and processing personal data does not mean you're outside the ambit. It means exactly the opposite. It means that the law will be applicable to processing of personal data outside India if it is in connection with offering of goods and services to data principals located in India. Just to give you an example, if there is an e-commerce website which is actively targeting Indian customers and wants to target Indian, more and more Indian users in a organized, well thought out, systematic manner, with probably the intention to generate business, although intention is not important. It's sort of, that's mens rea is not important at all. But if that sort of targeted advertising is happening and you're using personal data for that purpose, then you will probably be attracted and you would be required to comply under the law. But if you're basically passive and you're not doing much to target any customers, then potentially the law may not be attractive for you. Now, another interesting thing that we noticed is that profiling of data principles from outside the territory of India is no longer there. Profiling is behavioral monitoring, which is certainly a part of GDPR. But that's not to say that it's not applicable at all. If profiling is again connected to providing goods or services in India, then the law will be attracted and you will need to comply. So when does the law not apply, and what are the exclusions? So exclusions are also very clearly set out. If personal data is being used for personal or domestic purposes, so if I'm throwing a birthday party for my child and if I'm drawing a list of all my contacts with their contact details and everything, that's for personal domestic use, even though I may be preparing it on my laptop. So there I don't need to comply with this law. If then this is an important and unique feature which is coming next, which is the law excludes and does not apply to personal data that is made available publicly by the data principal himself to whom the data relates, or by any other person who's under legal obligation to make that personal data publicly available. This is an interesting one, and the example that has been cited even under the Act is that if the data principal has divulged certain details on her blog, then the law does not really apply to this information. So with that, we're going to shift gears and we're going to talk about, next slide please, we're going to talk about the grounds of processing which are recognized under law. So the first and foremost aspect and thing that we need to understand is that processing of personal data is only allowed for lawful purposes, and there are two grounds for processing. One is consent-based framework, and the other is non-consent based, which we have termed as certain legitimate uses. When consent is the ground for processing, you can move to the next slide, please. When consent is the ground for processing, then there needs to be a consent request, and that request needs to be either accompanied by or preceded by what we call a privacy notice. Does the law provide what the contents of this privacy notice should be? Yes, it does. In a great amount of detail, it tells you what exactly needs to go into the privacy notice. So what needs to go in is details of all the personal data that is being collected, the purpose for which it is being collected. The requirement of itemized notice has been dropped. But you need to also provide details of the manner in which the data principals can exercise their right to withdraw consent and obtain any sort of grievance redressal. It also needs to contain details on how data principals can approach the data protection board and file a complaint. So essentially, you need to educate the data principals on what rights they can exercise, and also how they can potentially sue the data fiduciary in case there is a breach under the law. Now, what is again unique to this law is that the privacy notice needs to to give an option to the data principals to access the notice either in English or in any of the 22 languages that is recognized by the Indian Constitution. So it's important for, again, companies to check whether they have adequate mechanisms in place today where they will be able to respond to this requirement quickly in case there is a data principal who wants it in a regional language that has recognition under the Indian Constitution. In terms of historic data, do you need a fresh consent? It's a question that we get often asked, and our understanding is that you don't need to obtain fresh consent, but you need to certainly furnish a notice as soon as is reasonably practicable, which will contain all of these items that we discussed in terms of what data you have of them, how they can exercise their right to withdraw, etc. So, with that, you can move to the next slide. Now, when consent is the basis, next slide, please. So when consent is the basis of processing, when it's the ground for processing, you need to obviously understand what consent entails, what is valid consent. And again, once again, the law provides a very precise, very well constructed definition of consent. It says that consent should be free, specific. Next slide, please. Can you move to the next slide? I think we're facing some trouble. Can you move to the next slide, please? Okay, I'm going to just, yeah, thanks. Right. So, like I said, the law provides a very precise definition, and it says that consent needs to be free, specific, informed, unconditional, and unambiguous. And it should be given through a very clear affirmative action. So if you have in your consent notice, if you have any sort of pre-ticked boxes, that is not going to pass muster. And you can't bundle it with terms of use, etc., so that people can't find it. So it needs to be very clearly given, and and there needs to be a clear positive action by the data principal while giving that consent. Now, consent also needs to be limited to specified purpose, and this is noteworthy because now the act is expressly limiting the validity of the consent to personal data that is necessary for satisfying a specified purpose. So this provision in reality is reinforcing and emboldening golden principles of purpose limitation and data minimization that now seem to be hard-coded in our law. So just to again give you an example, if there is a person who's given some personal data for using telemedicine services, and that the service wants to access the person's phone book, which is not necessarily required for for obtaining this service, then the consent that is obtained to access the phone book is going to be disregarded. So now the law is essentially legislating that consent that is taken for data which is not an essential prerequisite to achieve the specified purpose, it can be considered a nullity. So it's an important one to take note of. Then, of course, the data principal needs to have the right to withdraw their consent, and they have to be educated on how they can do that. And the withdrawal of consent should be as easy as the manner in which the consent was obtained. And what the consent request also needs to contain is that it needs to have the details of the data protection officer in case there is if you qualify as a significant data fiduciary, which my other colleagues will be taking up. And in case you're not a significant data fiduciary, then you need to put in the contact details who will for data principals of the person who will help them exercise their rights or grievance redressal. So I'm going to move to the next slide. Yeah, so the second bucket that we have is legitimate use cases. So consent cannot be the basis for all sorts of processing. For that, we have a second bucket, which is the legitimate use bucket. What is again noticeable is that we had a concept of deemed consent, which had crept in the predecessor iteration, that's been replaced by legitimate uses. Which also seems to be confusingly similar or a close cousin of legitimate interest under GDPR, but it's markedly different. So let's look at some of these relevant ones. The first legitimate use case is where the data principal herself has voluntarily provided their data and has not really indicated any sort of unwillingness to consent to its use. So again, just to give you an example, if data is provided in exchange of a service, I walk into a pharmacy, I give my phone number in order to get the receipt or invoice. In that case, the pharmacy doesn't need to take my explicit consent. Another example, I contact a broker to find me a rental accommodation, and he contacts me using that phone number that I've given. He doesn't really need to take my consent for it because it's understood. Of course, if I say I'm withdrawing my consent, please don't process my data, then he has to stop using that data. Then the other important piece which is recognized as a legitimate use under the law is when you're using personal data for the purposes of employment or for safeguarding the employer from loss or liability, such as corporate espionage, maintenance of confidentiality, IP, etc., etc. Then there are other things like in case of a health emergency, disaster, public order situation. In all of these cases, in case you want to comply with a judgment or a law, then you don't really need any consent, and this is a good enough use case in and of itself, to process the personal information. Next slide, please. Right. So lastly, this is a novel concept of consent managers. A lot of people are talking about it. We've not seen an equivalent sort of a concept under GDPR. So consent managers have been conceived to be persons who will be, of course, eligible, and that criteria will be subsequently published, but they will be entities of persons who will be registered by the data with the data protection board, and they are expected to serve as a single point of contact to enable data principals and individuals to give, manage, review, and withdraw their consent through an accessible, transparent, and interoperable platform. So it seems like this is certainly a new avenue which has come about, and potentially it is to address consent fatigues and to also empower individuals. And the government is then obviously likely to come up with eligibility criteria in terms of expertise, infrastructure, and other requirements to see whether these persons or entities are really worthy to be consent managers. And like I said, this is sort of novel, and we'll have to see how this plays out. I think with that, I'm going to pass back the baton to Supratim.
Right. Thank you, Anisha. That was quite enlightening. I think you have covered some of the most critical pillars of this particular law. But before I transition this to Harsh, I have a very important question which I see has come in our chat box for question, and that is, see, many are already compliant with the GDPR, and many think that they're compliant with the GDPR, and people are constantly comparing, okay, how good or bad or evil this is as compared to GDPR. So one question is that when you look at grounds of processing of personal data, how different is this from GDPR?
No, that's an excellent question. I think in terms of structure, overall, our law is fairly different. It's principles based. GDPR is much more prescriptive and hard coded. We have more flexibility. But on this specific question, I think there are a number of differences. And the first thing I think comes in the definition of processing itself. If you look at the DPDP Act, it covers processing of personal data which is either partly or wholly done by automated means. GDPR also covers processing through non-automative or semi-automative means. So that's number one. Second is we are looking at only digitized data, but GDPR also applies to offline data, which is part of a filing system. So there are a number of these things, and profiling is something I've already indicated. Any sort of monitoring of data subjects or data principals within EU is and if you're a data fiduciary or controller who's doing that, if you're outside EU also but you're profiling, the law is going to be applicable to you. But in the DPDP Act that we see, profiling has been dropped. So it remains to be seen how that's going to play out eventually. But these are some of the items that come to the top of my head. So back to you, Supratim.
I think the list is endless, and we have actually prepared a snapshot document which is comparing the DPDP Act with GDPR. So in case any one of you are interested, please do write to us. We'll also be very happy to share with you all. So with that, let me move on to Harsh. Harsh would be covering some of the, again, very, very important aspects. And these are key compliances in relation to data fiduciaries or data controllers, as we know in common parlance. We'll talk about the significant data fiduciaries, the different kind of data controller who has got higher sort of liabilities, responsibilities, and handling of children's personal data. To my mind, a lot of industries are rattled right now as far as children's personal data handling and how should they process it, etc. So Harsh, over to you. Super important points to be covered by you.
Thank you, Supratim. Can we have the next slide, please? Yeah, thank you. So data fiduciaries, I think we all are concerned about their compliances because all of us somehow or somewhere will have to deal with it. One important aspect relating to data fiduciary, I think we should keep in mind is that it is individual, body corporate, as well as the state, which could be a data fiduciary. So this is an enhanced definition compared to the law that we were following earlier, which was related to SPDI under the IT Act. And now the government is also equally responsible, barring the exemptions that they have to comply with these obligations. So with that, I think the first one is that the responsibility of compliance under the statute lies on the data fiduciary. So even if a data fiduciary is engaging a data processor, still the ultimate responsibility or the only person responsible under the law is the data fiduciary. This is important to note because even if somebody is processing on behalf of the data fiduciary, the only requirement under law is to have a valid contract between the parties. Now, what does this contract entail or what ingredients it should have? That is not spelled out right now. But looking at the various obligations of the data fiduciary, one has to be very careful while dealing with this contract, because these obligations will have to be trickled down to the data processor to avoid any situation of a data breach. So important obligations like keeping security safeguards or other requirements of erasure should be properly trickled down in this contract, and I would urge everybody to pay a lot of attention to this contracting. Next, I think it is important that correct basis of processing is utilized by the data fiduciary. We have already seen in the previous slides that consent and legitimate use are two such bases which Anisha discussed in length, and proper notice should be given in case of consent. We have seen the ingredients of the consent notice as well. Moving on, I think it is very important that the data, the personal data is complete, accurate and consistent. The responsibility lies on data fiduciary. And specifically when one data fiduciary is sharing data, personal data with another data fiduciary, or there is a decision being made about the data principle which impacts that person, again, it is on the data fiduciary to ensure that complete, accurate and consistent data is used in such cases. The next one is on erasure. Erasure again is an important one. In case the consent is withdrawn or the specified purpose for which consent was given does not exist anymore, that personal data should be erased by the data fiduciary, and also ensure that the data processor deletes all that data. Now, by way of an example, if an e-commerce company is given the data by a data principal for selling the car, and once that transaction is over, the car is sold, it is the duty of the data fiduciary to delete all of that data. Again, there is equally important to know that a data principal can also request such deletion, in which case the data has to be deleted. There are some safeguards provided there in terms of that such request should not be frivolous and it should be verifiable, but largely the duty of data fiduciary is to erase it. Numbers 7 and 8 are very important because there are huge penalties also associated with them. So in case of a breach, the breach notification should go not only to the board, but also to the impacted data principal. Now, this is very onerous for the data fiduciary because there is no threshold provided what kind of breaches need to be reported. Unlike GDPR, where there is a risk assessment that needs to be done before it is decided to whom it needs, whether it needs to be reported or not, in the DPDP Act, there is no such risk assessment that needs to be given, and therefore a lot of personal data breach notifications will have to be mandatorily going if it qualifies for a breach. To give you an example, person A is sending an official email to person B, and that email has a attachment with data of some of the employees, and this email goes to the wrong person accidentally. Even in such cases, it will be considered a breach because it will amount to unauthorized processing, and this will compromise the confidentiality of the data. Therefore, even in this case, the notification will have to go to the board as well as to the impacted data principal. And what it means is that the board also comes into picture. It can then inform the data fiduciary what next steps or corrective measures need to be taken, and also open an inquiry and understand what went wrong because of this breach. And of course, there are penalties associated with it. Penalties could go up to INR 200 crores in this case, which is USD $25 million. So one has to be very careful with data breach notifications. The eighth one is regarding reasonable security safeguards. Again, every data fiduciary should ensure that they deploy such safeguards to protect the personal data. However, no list or no ingredients have been provided what all should be included in these safeguards as of now. But looking at the global trend, processes like encryption, de-identification of data are some of the steps that are being taken globally to ensure there are security safeguards in place. So there could be a list that the government can release later, but as of now, there is no such particular list available for us. There could be policies that are in place to safeguard data that is also considered as reasonable security safeguards. Moving on, there should be a business contact information which should be published by data fiduciaries in case any data principal has to ask any question. That he should be able to send it to the right contact information being published. And finally, there should be an effective grievance redressal mechanism. It is the responsibility of data fiduciary to make it available to its data principals because they should not be left without any redressal mechanism in place. Can we have the next slide? We can go to the next slide. The next slide is on significant data fiduciaries. Unlike GDPR, where there are different sets of data, some are special category data while others is personal data. In Indian law, there are no two sets of data, but there are two sets of or kinds of data fiduciary that are possible. So significant data fiduciaries are those who are dealing with data which has a volume or a sensitivity which the government will later notify, which requires additional obligations to be fulfilled. Now, the government has given the parameters like volume, sensitivity, posing risk to the rights of the data principal, public order, and all of that. But the actual thresholds are not given as of now. However, looking at the global trend, we can at least say that those data fiduciaries dealing with a high amount of data, like for example, e-commerce entities or a telecom service provider having huge customer base, those will be considered high volume and could fall in this category. Again, sensitive personal data industries like those dealing with patient data, which is hospitals or path labs, those kind of data fiduciaries also could fall in this category. So what are those important obligations that needs to be complied in this case? First of all, a data protection officer needs to be appointed. This data protection officer should be in India and has to report to the board of directors. So he has to be a fairly senior person. However, no particular qualification or role has been defined as of now. Secondly, there should be an independent data auditor which should be appointed by a SDF, and it should evaluate the compliances of the SDF. Again, no qualification is given for the data auditors as of now, or what periodicity of audit they should conduct. There could be other measures that the government can prescribe, like for example, there is a requirement to undertake data protection impact assessments, periodic audits, which I understand will be an internal audit, and there could be other measures also that the government can prescribe in addition to these two. Again, no particular periodicity of audit is defined as of today. But yes, one has to note down that if a data fiduciary or a class of data fiduciary is significant data fiduciary in view of the government and it is notified, these additional obligations will apply in those cases. Can we move to the next slide, please? Coming to the additional obligations for children, first of all, let us see who is a child. So an individual who has not completed the age of 18 years is a child. Now, most of the global legislation and specifically GDPR defines 16 years as the age of the child, after which it is not considered a child, and it can be lowered down up to 13 years. So in that respect, there is a higher threshold available in India. There are higher level of obligations for child data processing, and a verifiable parental consent is required in that case. Now, how to take this verifiable parental consent, that is not explained as of today, but the government can notify how this can be taken. To my mind, if there is a process of taking consent which cannot be easily faked by a child, or some parental ID proof is required while giving this consent, it may serve the purpose, but we'll have to wait for the government to notify this. And this particular requirement of verifiable parental consent applies not only to a child, but also to a person with disability. Now, person with disability is not defined in the legislation as of now, but looking at definition in different statutes, specifically rights of persons with disability, it can include both physical or mental disorder. So we will have to see how this is interpreted finally. So if the data relates to personal data relates to a child, there are two main restrictions. One is that no processing can take place which could be detrimental to the well-being of that child, and there cannot be any tracking or targeted advertisement sent to that child, or there should be no behavioral monitoring of that child should take place. So these are the restrictions, these are blanket restrictions. So one has to be very careful, specifically those dealing with children data, hospitals having data of children, or edtech institutions, schools, colleges should take note of this. And in fact, everybody else, that they are not processing the personal data of a child, the onus lies on the data fiduciary. However, there is some hope in terms of exemption, where the government has kept some restrictions, kept certain exemption from these restrictions, specifically where purposes which will be defined by the government, which is quite open-ended as of today. And in certain cases where the central government is satisfied that a verifiable safe process exists for processing of children data, the government can permit it, which means remove these two restrictions and also specify a lower age for that processing. So again, all of this is very important for many data fiduciaries, and there is a heavy penalty also for not following these requirements. So one has to be very careful. We will look at the penalties while dealing with penalty section. So with this, I'll hand it over back to Supratim.
Yes, thank you, Harsh. Before I move ahead, I have just one question for you, which is kind of uh, a corollary to what you were talking about. So, are there any specific rights of the data principals or data subject, as we commonly know, that the data fiduciary needs to be aware of whilst performing their duties?
So yes, I think there are rights that are available with a data principal. And if you look at them carefully, they are just what we spoke about, the obligations of the data fiduciary. So there is a right to get grievance redressed. There is a right to amend or correct if the data is not correctly mentioned, or erase the data when requested. In addition to this, if there is any processing happening, the data principal can ask for a summary for that processing. It can also ask to whom my data has been shared. So all of that will have to be provided by the data fiduciary. So one has to take note. But one very outstanding right is right to nominate, where a data fiduciary can be asked that this is the person I am nominating. In case of my death or incapacity, this is the person who will take charge or decide on the processing of my personal data. So data fiduciaries should take note of this also, because they have to enable their systems to record nominations as well. So yes, quite a bit of homework that is required by data fiduciaries to be done here.
Great. Thank you so much, Harsh. I will move on to Shobhit right now. And Shobhit will be covering the last few important aspects of this particular new law. He will talk about cross-border data transfer regime, certain exemptions that are available under this new law, the adjudicatory mechanism under the DPDP Act, and of course, the steep penalties that are there for contravention of the law. Over to you, Shobhit.
Many thanks for that, Supratim, and a very good afternoon to all of you. Thank you for attending this once again. May I request the next slide to be projected, please? So let's touch upon data transfer to begin with. Now, data transfer is a ubiquitous concept in today's business world. Transfer of data is unquestionable and almost a reality that we have to deal with in our day-to-day functioning. Now, if we compare the concept of data transfer as exists under other jurisdictions, and particularly under the GDPR, for example, there are a fair degree of prescriptions that have been provided there in terms of the steps that need to be taken before such a transfer can take place. Additionally, there have been judicial precedents that have added to another layer of protective measures that need to be taken. In fact, even the existing law as it stands in India today under the Information Technology Act and the SPDI rules talks about certain preconditions that need to be met. The previous iterations of the personal data protection bills that we've seen over the last 5-6 years have also given a myriad types of suggestions in terms of how this concept should be dealt with. But finally, what we see as a part of the Act is a fairly simplistic approach that has been adopted by the government. And in simple terms, the approach is really where the government will notify a set of countries or territories outside of India to which transfer of data will not be possible. Now, in addition to that, there are certain laws that do afford a higher degree of protection as well as restrictions on transfer, and such laws will remain unfazed with this Act. In other words, that protection or that restriction on transfer on a sectoral basis would continue to prevail. But whether or not there could be additional requirements, something akin to what we see under the GDPR, like having standard contractual clauses, binding corporate rules, or having to meet a particular adequacy requirement. Whether these type of prescriptions will come out will have to be seen when such notifications are rolled out. So for now, it seems to be a fairly simplistic approach that has been adopted. But going forward, of course, it will have to be seen what measures the government brings in to regulate this space. Moving on, I'd like to touch upon the exemptions that are available under the TPDP Act. With that, can I request the next slide, please? Thank you. So, apart from a few provisions of the Act, which primarily affix the responsibility of compliance with the data fiduciary, as we saw in the previous segment, along with the requirement to have appropriate safety safeguards to prevent personal data breach. Now, apart from these two provisions, all other provisions of the law will be exempted for certain situations. Now, what these situations are require a close look in. Of course, some of these on the face of it are self-explanatory. So when you talk about enforcing a legal right or claim, where the processing of personal data may be necessary for performance of any judicial or regulatory function by a judicial authority, where a processing may be required for the interest of prevention, detection, or investigation of an offense. But there are certain other exemptions that may be potentially availed by businesses and may be of quite a bit of relevance in today's day and age. So for instance, if we draw our attention to the bottom of the screen, wherever processing of personal data relates to data principles that are located outside of India, and such processing is being undertaken pursuant to a contract with a foreign party, there is an exemption granted for such an activity. So we have always started India as a huge outsourcing hub, and this exemption will really do wonders to that, because there is a great deal of data, foreign data subjects, that is being processed in India, and that is being done with contracts that are there with foreign parties on the other side. So this will definitely help in easing out compliance for many of these entities. Of course, the obligation to have effective measures in place to prevent personal data breach is an important step that needs to be still taken. But yes, it will do a great deal of benefit for the outsourcing industry in that sense. Similarly, another measure to aid business is where the processing of data is necessary for a scheme of merger, compromise, arrangement, or amalgamation. And when such a activity is being undertaken by a court or a tribunal, then the processing in that regard is also being exempted. Similarly, for financial institutions in particular, where there may be a need for ascertaining the whereabouts, the financial information and assets and liabilities of people who have defaulted in payment of claims, then the processing that takes place in that regard can also be exempted. In addition to these general exemptions, there are also certain exemptions that have been carved out for the government. So where processing of data is essential for carrying out any activity which may be in the national interest, for preventing any sort of threat to public order and so on and so forth, there can be exemptions granted to the government and state instrumentalities of the state in that instance. The Act also paves the way for exemptions for certain data fiduciaries and classes of data fiduciaries, and particularly startups, where the government may, after having regard to the nature and volume of the data, exempt the application of certain additional provisions of the Act for such entities. Now, when it comes to startups in particular, this will definitely bolster that space. But what criteria will be prescribed for classifying a startup? That is something that will come about in due course. But it's definitely an important area to keep track of, and it can be put to much avail in coming times. There are also a general set of exemptions that the certain powers that the government has to exempt certain data fiduciaries or classes of data fiduciaries from the application of the Act altogether, provided these sort of notifications are issued by the government within 5 years of the commencement of the Act. So say if it comes into force on 1st of September, then 1st of September, 5 years down the line, that is the time frame within which these kind of notifications can be issued. So with that, I would like to move on to the oversight and the enforcement mechanism that has been envisaged in the Act. And can I request the next slide, please? Thank you. So starting off, I think as we've already touched upon in our segment on the duties and responsibilities of a data fiduciary, the cornerstone of empowering a data principal is really to having a robust grievance redressal mechanism, and that happens to be the first port of call where a data principal, if they're aggrieved, that's the first door they can knock on in an organization in case they have any grievances or questions regarding how the data is being processed. Now, this can be in the form of a complaint that is made to the Data Protection Board of India. And with that, I just take a pause to talk about what the Data Protection Board of India is. And this is something that is going to be similar to in many ways, but also different to a supervisory authority as we've seen in the GDPR. But it is mostly concerned with adjudicatory and enforcement functions. So the Data Protection Board is intended to be an independent body, and it will function in a manner as of a digital office, which means it can be digital by design in terms of manners relating to allocation, hearing, as well as pronouncement of its judgments. So when such a complaint is made to a data protection board, it can take cognizance of that and proceed with an inquiry. Similarly, there are different avenues available to the data protection board as well, where, for instance, if there is an intimation made for a personal data breach, as we saw in the obligations for data fiduciaries, they have to make those intimations to the board as well. So in the case of such an intimation, and also in cases where a reference may be made by the government to the board. So these are the three avenues of taking cognizance of any contravention. And as a first step, what the board will do is they will firstly examine whether there is enough merit and sufficient grounds to proceed with an inquiry. And if not, they will close it there and there. But if on the other hand, there is some merit, they will proceed with an inquiry, and in doing so, they will follow the principles of natural justice and also grant opportunities of equal hearing to both the sides concerned and take decisions accordingly. Now, ultimately, they could pass a direction or even levy penalty, and which we'll talk about in just a bit, against the concerned person. And before doing that, they will offer them an opportunity of being heard. If any person is aggrieved by an order that is passed by the Data Protection Board, an avenue of appeal is available in the form of an appeal to the TDSAT, which is the Telecom Dispute Settlement and Appellate Tribunal, which has been designated as the appellate authority under this Act as well. Now, the appeal in question has to be filed within a time-bound manner. And similarly, for disposal of the appeal, there are timelines that can be prescribed as well. Because the TDSAT really finds its genesis from the Telecom Regulatory Authority of India Act, then pursuant to its provisions, any order that is passed by the TDSAT can be appealed before the Honorable Supreme Court, which acts as the final court of appeal in this case. So this marks the adjudicatory hierarchy that is envisaged in the DPDP Act. But in addition to that, there are also certain new concepts that have been introduced. So first of which is the concept of alternate dispute resolution, and this can happen at the stage where the Data Protection Board takes cognizance of a particular contravention. So wherever they feel that it is possible to adjudicate this or address this by means of a mediation between the parties, they can refer the parties to mediation, and this will definitely boost the cause of ADR, as we've seen in many other laws in recent times as well. Another concept that has been brought in to boost ease of doing business and will definitely provide a lot of leeway to a lot of the smaller companies is the concept of a voluntary undertaking. Now, in simple terms, voluntary undertaking here refers to an undertaking that is given by the concerned person to undertake a certain action or refrain from undertaking that particular action for a particular time period. Now, if that undertaking is put in force, that will constitute a bar on proceedings against that person. And it is possible for the board, with the consent of the person who gave the undertaking, to change the terms of the undertaking before it becomes binding on them. And of course, if there is contravention of this voluntary undertaking, then they can proceed ahead in the manner in accordance with the penalties that have been prescribed. Now, speaking of which, we'll discuss the penalty structure that has been envisaged and contemplated under the Act to act as a strong deterrent against defaulters. Can I have the next slide, please? Right. So as we saw, upon conclusion of the inquiry, the Data Protection Board can levy certain penalties for contraventions, and these penalties, as we saw previously, will be levied after giving a due opportunity of being heard to the person concerned. As you will see, the penalty in their amounts are quite hefty and will definitely act as a strong deterrent. But one thing that is missing here, which we've seen in the previous iterations of the law as well as versions of the bill, is the absence of an overall cap that exists on the penalty. So potentially, if we talk about a scenario where a personal data breach has taken place, so we could be looking at a situation where the data fiduciary in question has failed to take reasonable security safeguards to prevent it, and perhaps if they've also failed to notify the board or the concerned data principal, then both counts of those penalties can be levied on them. And these penalty amounts are quite sizable, as we can see, and really don't draw any linkage to the revenue of the concerned data fiduciary, which is at variance to what we've seen in the GDPR. Now, of course, because these are upper limits to what these are upper limits of the penalty amounts, there are certain factors that may be at play in deciding the quantum of penalty that can be levied finally. And those kind of factors are determined on the basis of the type and nature of data that is involved, whether the breach is happened more than one or two times, what the gravity of the offense is, excuse me, what were the mitigation steps that were taken by the data fiduciary, and what impact really will this levy of penalty have on that entity as an impact of this. So all of these factors will be given due consideration before it can be levied, and it will have to be seen what kind of enforcement trends this will really roll out, because these are sizable in nature, as we've seen, and there are quite a few strong deterrents that are available. With that, I'd just like to move on to the next slide, where we'll take just a few moments to recap what we've seen so far as a part of the landmark transformation that is taking place in the data protection landscape in India. So first and foremost, the Digital Personal Data Protection Act covers digital personal data, as we've seen. There's really no dedicated coverage of non-personal data in this version of the law. And we've seen that there was a, in the previous iteration in the 2019 and the 2021 bill, there was some talk of non-personal data being covered as well. There was a separate framework that was under discussion some time back, but that is yet to sort of actualize and take effect. When it comes to classification of personal data, there really isn't any further classification apart from personal data itself. So in other words, there's no sensitive or critical type of clarification. We saw that the cross-border transfer mechanism has been considerably watered down and made simple. And unless it is specifically prohibited, personal data transfer will not be impacted. And of course, laws which otherwise offer a higher degree of care and protection towards certain types of data will continue to prevail. At an operational level, we've seen that data processors don't really have any direct obligations under this act. And a lot will depend on and hinge on what kind of contractual trickle downs take place between data fiduciaries and data processors and how those enforcement will take place. For children's data, it's good to know that there are dedicated provisions now in our legal framework that talk about protection and added measures that need to be taken for our younger section of our population who are increasingly getting entrenched in the use in the digital space. When it comes to notifying the board as well as the personal data, the data principles in case of personal data breaches, the departure from GDPR in the sense that there is no materiality or risk-based threshold really poses a lot of operational difficulties for entities. And as we saw, even an inadvertent email that is sent erroneously can also trigger that sort of obligation. So it'll have to be seen how these will be streamlined after the commencement takes place. And lastly, the penalty structure is, of course, designed to be highly deterrent, but the absence of the cap of an overall cap will definitely, hurt businesses somewhere. But the bright side here is that, of course, there are no criminal sanctions anymore. There is no imprisonment or fine that is spoken about. So that's definitely something great to take away. So with that, I'd like to hand it back to Supratim and take it away from that. Thank you.
Thank you so much, Shobhit. And I have a very difficult one for you. I just chose the most difficult question that has come through.
Okay.
And the question is, how will the government notify the list of restricted territories where transfer of personal data is not permitted?
Okay, so I'm actually glad you asked that question because the Act has interestingly covered this in a very specific provision. So, where there is a, when such a notification will be issued by the government, it's not something that the government can do on its own entirely. The notification will have to undergo the prescribed process, and which entails it being presented before both houses of parliament and asking them to mull over it before it can be signed as a notification. So there is a process that has been envisaged within the Act itself to enable this sort of notification to take place. But of course, we'll have to see what kind of factors will dictate this. We've of course seen it in different spheres, but yeah, it'll have to be seen how and what kind of notification will be rolled out.
Great. Thank you so much, Shobhit. And now I would request all the speakers to come on camera, and maybe we can just take some of the questions and let me start pulling them out. Anisha, I think I'll ask you a set of two questions. First question is your reading of the law that no reconsent is required for historical data that has been already collected in the present regime, the old regime, as compared to when it will transition to the new regime of the Digital Personal Data Protection Act? That's the first question. Second question is, there's no segregation between personal data and sensitive personal data right now. Is this a good thing or a bad thing?
Okay, so I'll take the first question first in that order. I think I had indicated that in our view, we don't think a fresh consent per se is required for any historical data. You of course need to still send a notice to everybody whose personal data you have. You need to send that as soon as it is practicable once the law has been enforced. And you need to have in that notice all of the items that we had initially talked about, what personal data you have, what is the purpose for which you need that personal data, rights for withdrawal, redressal mechanisms. So all of those things need to be listed in that notice, but you per se don't need to take fresh consent. That consent remains valid. Of course, if an individual after receipt of that notice realizes that he doesn't want to continue that consent, and he has the ability to then sort of withdraw the consent, and then it is incumbent upon the data fiduciary to stop processing that data immediately. And again, would like to add, I think personally that this is a practical learning from our GDPR experience, where we were bombarded with a lot of emails to take fresh consent. I think the government has recognized that, which is why we have a provision which is slightly lighter and softer in approach. The second question is a hard one. Is having no classification and having a flat structure, is that good, bad, ugly? I think time will tell. That's my first reaction. But my second reaction is that while it's sort of a flat structure and everybody seems to have the same level of compliance irrespective of the data that they are dealing with, there are provisions which sort of recognize that if you're dealing with high volumes of sensitive data, which poses risk to individual, then you are qualified as a significant data fiduciary. You will have more obligations. You will have more compliance burden. And if you're a startup, again, it's worded very beautifully. And again, we'll have to see the rules depending on the class of fiduciary, depending on the nature and the type and the volume of data that you are processing. You may benefit from that compliance reduction in compliance burden, and you may not. So if you're probably a startup which is dealing with very sensitive data on, let's say, biometrics or genetic data, potentially you may still qualify as a startup under DPIIT rules, but you may not for the purposes of this act. So like I said in the beginning, it's a principles-based legislation. I am hopeful that the government is mindful of all of the experiences, and while there is no specific categorization, suitable checks and balances and safeguards will be put in place to ensure that there is some sort of equal treatment for equals and different treatments for where the business models can be differentiated.
Excellent. I just had another additional thought, Anisha, that if you look at the penalty related provisions, which Shobhit was alluding to, one of the parameters how you can go up to the highest number is the sensitivity of the data that you have actually breached. So in the sunrise period, whilst it is all mushy and nice that you need not do anything special for the sensitive kind of personal data, but in case there's a breach of sensitive kind of personal data, the penalty quantum could be high. So, I think as this unfolds, I completely agree with you. It could actually show true colors. But anyways, I'll go to the next question.
Just one interjection here, if it is permitted.
Yes, please.
I think one of the reasons why it is like this, where sensitive and personal are not differentiated, could be to keep the legislation simpler. This is a distinction where throughout the legislation you will have to talk about the different kinds of data and what additional obligations apply. Instead, I think they have categorized it as significant data fiduciaries, and then specific only those data fiduciaries get those additional compliances. So in my view, this makes it much simpler to understand, and maybe that could be one of the reasons why the government took this decision.
Also, Harsh, I'll tell you, I think when we were having the deliberations, I think one thing came out very clearly. If organizations at every size and nature, right at the beginning, right now, have to sift through and understand where sensitive data, where personal data is seated and treat them differently, the starting point itself would have been very difficult. So absolutely agree with you. But anyways, I will move on and I will ask a very tricky and difficult one to you, Harsh. And the question is like this: there is no statutory penalty specifically provided in relation to data processors in this new law. So the only remedy for data controllers or data fiduciary, as they call, is to recover the amount contractually, maybe, back-to-back indemnity, etc. This can take forever in India. So what is your take on this?
Okay, so very, I mean, not an easy one to answer, but I would differ that it will take years in India to get that kind of compensation. And the reason is that there could be contractual clauses and there could be ADR mechanism agreed in those clauses between the fiduciary and the processor. And arbitration has become much quicker than what it was before the amendment to the Arbitration Act. So there is a time limit also that within which an award should be given after the proceedings are over. So it's not that it will take ages for that decision to come, but yes, during that period also, it is a bit of a challenge for data fiduciary in terms of first paying up and then recovering from the data processor. But as I said, the contracting is very important during my presentation also. So enough thought will have to get into this in terms of depending on, first of all, while choosing the data processor itself, there should be proper diligence. And secondly, I believe there could be some mechanism depending on the size of the processor or bank guarantee, escrows and others built in, including liquidated damages if it is possible to negotiate them. Of course, the negotiation power will differ depending on the type of parties involved. But slowly, I think it will become a market practice where these safeguards are built in the contract itself. And to give you an example, something similar happened in telecom industry many years back when vendors were being selected for procurement of 3G equipment some years back, and there was a requirement from the government to penalize the telecom service provider in case of any malware in those equipment, and those were trickled down to the vendors in that case. So this situation is also very tricky because everything has a cost attached to it, where as and when the processors are made to give anything in terms of escrows or corporate bank guarantees, etc., the cost of processing will also go up. So yes, it is a very tricky situation to be in.
Great. Thank you so much, Harsh, for that answer. I will move on to Shobhit. The next question is for you, Shobhit. Apart from financial penalties, what are the other actions that can be taken under this new act?
Right. So we of course saw what the financial penalties are, and they're quite significant in nature. In addition to those, the government also has certain special powers that it can undertake under the provisions of this act, where, for instance, if a reference is made to it by the board, and that reference can be made by the board in two situations, essentially. So one is where the penalty has been levied on a particular data fiduciary in more than two occasions, in two or more occasions. And the second is where the board also perceives that there could be a threat to public interest, where the platform of the particular data fiduciary poses a threat to public interest. So in those type of situations, the government even has the power to block access to particular platforms. So which seems to be a slightly harsh measure here, and has been a hotly contested one as well. I'm sure it'll raise a lot of eyebrows when it is rolled out, but a lot of people have actually questioned the placement of this in this particular legislation. But yeah, that is one significant thing to take note of going forward.
Great, thank you. Harsh, the next question is for you, and very important one. How good will TDSAT be as an appellate body here in this context?
All right. So see, TDSAT is a special tribunal, and it has been performing, or rather multitasking, in the past as well. So this additional duty obviously is something which the government will have to consider carefully, because there are a lot of pending cases already in TDSAT. I think there are more than 5,000 cases that are pending there for various reasons. So giving this additional responsibility also requires some additional task force, or increasing the size of the tribunal, or maybe adding a bench to it so that they can cater to this requirement as well. In my understanding, the litigations will be heavy in this particular area, because every data breach needs to be reported, and then there could be a fall off from there. So TDSAT has to be equipped to deal with so many cases. So that's my limited take. I think if the bench strength is increased, it will be a good forum to take all the disputes to, as an appellate forum.
Great. Thank you, Harsh. Next one is for Anisha, and I'll read it out directly from the chat box. It's saying, so in deletion request, does it make assurance to delete from a fiduciary point as well as all the third party it has been shared with? Yeah, thank you.
Right. So I think the question is, if I understand it correctly, the question is that does the data fiduciary need to make sure that all of his third-party processors need to delete the information? So yes, no, the short answer is yes. See, the landscape of the entire law and the overarching theme is that data fiduciary, or the controller, is the guy who's in the driver's seat. He's the one who's calling the shots. So he's the one who should be responsible. So the entire responsibility is pinned on this data fiduciary. GDPR, of course, has a lot of direct obligations on the processor, but our law does not have that, which means that if I am a data principal and I have exercised my right to withdraw, or you, as a data fiduciary, you have achieved the specified purpose for which the data was collected in the first place, then you, as a data fiduciary, need to delete that from the systems. That's the principle of data retention. You can't retain it unless it's required for a legal purpose, right? And you need to make sure, therefore, that that message is communicated to all your downstream third-party service providers, your vendors, your processors, etc. So it is your responsibility, and in case that doesn't happen, then your neck is on the line. So as a data fiduciary, you are going to be liable, and which is why it goes back to what Harsh had said earlier. You need to rethink and relook at your processing agreements with your data processors, and really need to tighten it in light of the enforcement issues that we have in our country, and see, you know, what best works to make sure that your commercial and business interests are protected, you know, in such situations where the data processor faults, and you know, you still have to face the music.
Thank you, Anisha. I'll stay on with you, and there's one more question. It says, from a business to business standpoint, there are two parts, that is commercial data and personal data, like directed details, etc. Would this get applicable to B2B database? And if yes, to what extent?
See, yeah, so I think the idea is simple. To the extent the data is not relatable to an individual, it's not a personally identifiable data, that is outside the purview of this act. So when you're dealing in a B2B business space and there is commercial data, so, you know, terms of your negotiations or any commercial contract which does not have any individual identifiers, that can be totally carved out. Your obligations will get attracted only to the extent it relates to, you know, director's personal information that is captured there. So you can slice and dice that entire whole piece of information that you receive into what data is actually personal, you know, carve that out, apply the law only to that. Your obligations under the law only apply to that, and the rest is all commercial outside the purview. That's the simple answer.
Thank you, Anisha. Next question is for you, Shobhit. So what are the remedies that data principals really have under this law?
Right. So I think, of course, the law has really kept the enforcement on data fiduciaries quite stringent, as we've seen. in terms of the fines that have been and the penalties that have been prescribed. But strangely enough, and we've seen this in the previous iterations of the bill, and in fact, it's also a part of the current Information Technology Act. There is a right that the data principal has to claim compensation in case of any breach that takes place. Of course, there are additional grounds and requirements to be met in that case, but strangely enough, the Act does not speak of any direct compensation that may be payable to a data principal. We of course saw that the data principal will have an avenue to approach the data protection board in case of a contravention, and that's where it may take its course. But yeah, for now, it doesn't seem like there are direct avenues that may be available for a data principal.
Right. Anisha, one last question that we'll pick up, and that's to you. It's a fun question, I think, maybe a tricky one as well. Translation of notice and consent related documents into 22 languages. Was there a better way to handle this issue?
Let me attempt that answer, and Supratim, maybe I'll invite you to also chime in. So yeah, I mean, I think at first it seems like a slightly onerous requirement, especially when we are trying to make concessions and make life easier for say startups and certain data fiduciaries. But the second instance, it seems like to some extent it is also fair that if you are a business who's targeting a particular region, you can't just say that I'm going to give you the notice only in English, right? So if I'm in, let's say, if I'm in Tamil Nadu, so I should be, and if I'm targeting that region, then I should, as a resident in the area of Tamil Nadu, have the ability to ask them that can you give me a notice in the language that I comprehend, right? But I mean, could the law have been, instead of making it a blanket obligation that everybody should be able to provide that option, restrict it or put some more conditions where it is more tailored and customized, to that particular region, or put some other sort of conditions to make life easier for them where it's not a blanket sort of an obligation. So I do think that it could have been done. It's not been done is another thing, but again, Supratim, why don't you give your views on this?
Yeah, thank you. No, I think we fought hard against this, as in, of course, we are all in. We understand the underlying reason why, this notice and consent should be made available in different languages so that it is at least accessible to the larger population, different kinds of, languages people speak and read. And therefore, what we had said is, suppose it's an OTT app which is showing, say, a Tamil movie or a Bengali movie, then you need to show it in that language. It makes sense. But for every single player in India to translate these into 22 languages is operationally and otherwise also it's quite challenging. But it seems like the government really wants to go ahead with this, and they have stuck to this point. But one interesting thing I must tell you, Indians being Indians, we've already started hearing some, interesting thoughts and chatter in discussions like these. So if you read the language, it's saying that, the data fiduciary shall give data principal the option to access the content in English and other H scheduled languages, which is the 22 languages. And this gentleman says that, listen, I will write this exactly in a similar manner in my notice and consent that here is the thing in English, and you have option to come to me for all those 22 languages. The day anyone comes, I will send it for translation. So another way of looking at it, but yes, let's see how this goes. Sorry, Harsh, you want to say something?
So I was just saying that maybe it is a little scary to read this in the first go, and we were discussing with one of the clients about how to go about it. And there is a real possibility that in few days or few weeks we can have a software which will convert the English language notice to all the regional languages, which is not perfect but is good to go. And this high burden of translation and can be met by most of the data fiduciaries going forward in this way. So technology may have an answer to what we are debating right now.
No, of course. So thank you so much. Unfortunately, we'll have to bring the Q&A session to a closure right now. Of course, tons and tons of questions have come. We will be responding to them over email. I would now like to thank each one of our speakers for sharing their views on the Digital Personal Data Protection Act, drawing from your practical experiences and expertise in this domain. To our audience, I hope you found this webinar interesting and worthwhile for the investment of your time. We certainly enjoyed bringing this to you. After the webinar, we will send you a copy of today's presentation material and a link to the webinar recording. You will also separately receive a request for your feedback on the webinar. Please take the time to send us your feedback, comments, criticism, and even compliments. The form takes less than 1 minute to be completed. Please do not hesitate to contact us regarding any matter arising from this webinar. Our contact information was already reflected in the contact slide. It will also be shared when you get the slide deck. Thank you now for attending today, and we look forward to seeing you again very soon. Thank you very much.
Thank you.
Thank you so much.
Thanks. Bye.